If you could unmute your microphone, and we are ready to proceed with your argument, sir. Excellent.
Good morning, Your Honors. I am Robert Donald from Fort Myers, and I'm here on behalf of your appellant, the former husband, Greg Toth. I'm opposed by Stacy Haverfield, who's out there in cyberspace somewhere, and she's here on behalf of the former wife, Stephanie Miller. I would like to reserve 5 minutes for rebuttal, if I may.
Very good, sir. Thank you.
We're appealing here from a second amended final judgment of dissolution of marriage. If this feels like deja vu all over again, it's because the parties have been before this court previously. The former husband appealed from the final judgment and the related orders and judgments arising from it. This court reversed. Judge Kelly, writing the opinion, found that the trial court had committed what we call a Berg-Perlow violation. The 65-page amended final judgment had been prepared by opposing counsel, and the trial court signed it without change. And Judge Kelly and the two other panelists found that it was not the product of the court's own analysis and independent judgment, and therefore reversed for reconsideration. And what I will do is read from the end of Judge Kelly's decision. What she says is that we, of course, affirm the divorce itself, but, quote, we reverse the remainder of that judgment and remand with direction that the judge enter a final judgment reflecting his independent decision-making consistent with the evidence and applicable law. In light of our reversal of the amended judgment, we also reversed the money judgment entered in favor of Ms. Miller pursuant to that judgment. The case then went back to the trial court, and the trial court then entered its second amended final judgment, which made the exact same holdings on the exact same rationale as the amended judgment. So here we are again to test the merits of the trial court's awards of both marital and non-marital property to the former wife. These issues, because of the disposition of the prior appeals, were not reached on the prior appeals. Perhaps I should begin with an apologia here and state that we have raised a number of points on appeal, maybe as many as this court has ever seen before.
I have to say, Mr. Donald, I think you get the record as to the most issues on appeal on any case that I have ever seen, sir.
Well, it's a dubious record, but one that, you know, I'm not glad about. But I have raised these points in the good faith belief that each and every one of them would support reversal in its own right, and that taking together, they certainly show the grave damage done to the former husband by the second amended final judgment. Obviously, we're not going to be able to discuss all the points on appeal here today, but my goal is to spark or pique interest so that from what we do discuss here today, the court will be moved to look at the points that are not discussed and see the grave damage done to the former husband. By way of background, and the background is going to have to be brief because the facts of this case are very convoluted and complicated. Parties were married a little bit over 8 years, so between 8 and 9 years. But even before the marriage, they did business together. In fact, they owned property together. What they was realtors, entrepreneurs, land assemblers. What they would do is they would enter into complicated land transactions with, quote, the money people. They would find land and assemble it and then purchase it with the money people. And in exchange for their services, they would get a small minority interest in the project itself. It was conceded by all below that all the money earned in this marriage went into a marital pot, and that there was nothing segregated or in one spouse or the other's name. Or yeah, there were some things that were in their individual names, but everybody concedes that this was marital property. The first point that I've raised in our initial brief is that the trial court erred in entering a $400,000 judgment against the former husband for what can only be termed a special equity in favor of the former wife. If you look at the second amended judgment, what you'll see is this award was termed non-marital property of the former wife. And so it's essentially a $400,000 personal judgment against the former husband. The basis of this judgment is what she supposedly injected of non-marital funds, her non-marital funds, into two marital properties, one of which was the office building where the former wife conducts her real estate business, and the other is a Miller Family Trust, which is a estate planning vehicle the wife set up before the marriage that is participated in by herself and several of her own family members. Note that these two pieces of property for which the former husband was found to owe the former wife $400,000 were found to be marital property and were distributed to the former wife for minus values. The family partnership for a minus $27,000, the office building for a minus $155,000. So there is a $400,000 judgment against the former husband for the former wife's injection of money into properties that now both have a negative value. And of course, by finding these properties to be marital and assigning them to the wife and giving them a negative value, she in essence got a credit in the equitable distribution that had to be made up. So this is not only the $400,000 judgment against the former husband, it's also the effect of finding this to be marital and of negative value and then distributing them to the former wife.
Mr. Donald, I had a question on that though. I understand what you're saying is it was a bad investment or there was negative equity at that point in time, but as a trial judge, they're looking at what was contributed at the time. So who owned what part of a bad investment? So why should you wait till the end of the bad investment or what ends up being a negative equity at the time of the divorce and say, since it's a negative value now, we can't consider what the parties put into it?
Judge Stargell, I'm not, let me see if I get this, what you're saying here. If the trial court had said, well, gee, the former wife put money into these two assets and therefore she should get them, fine, or she should get.
I'm not saying that at all. I'm just saying as a general rule, it seems what you're asking us to do is to say the trial court erred because they didn't consider what the value was at the end of the day. The fact that it ends up having a negative value really doesn't have anything to do with apportioning what the parties put into that investment. If it had been, if it had been a great investment and ended up being worth $5 million, there still would be consideration from a marital property versus non-marital property as to what it was put into it.
But Judge Stargell, the trial court didn't apportion anything. When you say apportion, I mean, if the trial court said, well, gee, the wife put in 60%, the husband 40%, but that's not what the trial court did. What the trial court did is it entered a money judgment against the former husband for $400,000. Okay, it's really that simple. And it appears,
but it's based on all of the relative values, and that's where he put it. Correct? Is that okay? This is what, when I've added it all together, what he owes.
I don't think relative values had anything to do with it. This was a tracing by the former wife's expert.
Correct. The total values. It has to come out in the wash somewhere. There has to be an equalization.
But it doesn't exist. I mean, there's an equalization of marital property. I understand that. And I understand that the trial court could have valued the marital property differently. But the trial court valued the marital property at zero or less and entered a $400,000 plus money judgment against the former husband. And the only way in the parlance of divorce law that this makes any sense is under the concept of special equity. It used to be in the old days, if you injected money into the marriage, you could say, gee, I have a special equity. Usually it was the husband claiming this and the wife, disputing it. The husband, let's say, paid $400,000 for the house, the marital house, from his non-marital funds. He would say, I should get the house. And that was called a special equity. The problem is that special equities, the concept of special equity was done away with in 2008. Chapter 61.075 sub 11 says that special equity no longer exists. So there's no way to have a special equity as the trial court has awarded here in the form of a $400,000 judgment against a former husband that is labeled non-marital property, which is how special equities were treated in the old days. They're not, they don't exist anymore. What they've been is subsumed by the concept of unequal distribution. The trial court can still take into consideration who put the money in and is deciding how to distribute property. But it's in the context of distributing marital property. It's not a non-marital award. This court, has been one of the leading courts in talking about this and said that special equity doesn't exist anymore. And the only relevance is to the distribution of marital property, okay? Here, it wasn't a marital distribution at all. It's labeled in the judgment as a non-marital distribution, and looking at what it really is, it's a $400,000 judgment against the former husband and in favor of the former wife for supposed injections into property that is now of negative value. If the trial court had distributed the property to the wife, as it did, that's within its rights in doing an unequal equitable distribution. But the $400,000 judgment is the problem here, and what we're attacking is as an invalid special equity that no longer exists. The tack taken by the former wife on appeal is, well, the trial court was inartful in what it said this thing was. Even though it looks like special equity, what it really was unequal distribution of property, okay? But it's not unequal distribution of property. It's not distribution of property of any kind. It's a judgment against the former husband. So you can't shoehorn this into equitable distribution. It just doesn't work. It's a special equity, plain and simple. It really can't be anything else. But let's pretend like it does fit within equitable distribution. The problem from that standpoint is you got to prove two things to get an unequal distribution because of your insertions of non-marital money into the marriage. You've got to trace the money, but more importantly, you've got to overcome the presumption that a gift was intended. 61075 creates a presumption that a gift is intended when you insert non-marital funds into the marital pot. And everybody conceded here that the money was put into a marital pot. There's a long list.
Wasn't there some debt that was just the wife's debt? I mean, how would you have them offset? I'm looking for the error for the trial judge and trying to put myself in their position. I mean, at a certain point, if there's debts that are the wife's alone, or there's other expenses that need to be equalized, what would you have had them do different if there's not enough cash capital that he's put in there?
Judge Stargell, the $400,000 has nothing to do with that. You're right. There was a debt associated with the office building where she conducts her real estate business, and that was distributed to her for a minus $155,000. but then she got a credit of assets for $155,000. So the debt associated is taken care of in the equitable distribution. This $400,000 is outside the equitable distribution. It's a judgment against the former husband that, if you have to label it anything, what the trial court said is sort of, I guess, as close as you can come, is that this non-marital property, just as in the old days in special equity, that's what a special equity was non-marital property. But again, getting back to the point I was just making, is no matter what it is, if you shoehorn it into equitable distribution, she did not prove the second element that she had to prove. And that is that no gift was intended. As I said, 61075 specifically states that there is a presumption of gift. And it also specifically states that this presumption can only be overcome by clear and convincing evidence.
Mr. Donald, I just want to let you know you're about to get into your rebuttal time. Feel free to go forward, or do you wish to remain the remainder for rebuttal?
Let me go forward a little bit. I'm really not even through with the first point yet. So, anyway, this court has spoken to this issue a number of times in Gardner, Zingari, both cases decided in 16 and 03 that says if there's not any evidence or any finding of gift, such an award as this cannot be affirmed, whether it's deemed to be special equity or unequal distribution. Here, there was absolutely no evidence of to overcome the presumption of gift by clear and convincing evidence or otherwise. So this $400,000 judgment against the former husband just has no legal basis. And there's a bunch of cases from this court that are right on point that say that you can't make a special equity award like the trial judge did here. Let me see.
Mr. Donald, isn't it relevant that this infusion of monies was into her business? Isn't that, a lot of the special equity cases arise in the case of the marital home, as you point out, but this was her business that she had been in business for 20, 30 years. She brought him into the business during the course of the marriage, but this was hers, and this was something that she was going to continue pursuing after the marriage. So isn't that a relevant factor?
I'm sure I'm gonna murder your name, but I'm gonna try it. Judge Rothstein Joachim.
Perfect.
It's really not, I'm not sure the point you're getting to, but remember, this is the building, not the business. Now, the business is conducted in the building, but this is not her business. That's another asset. And you say it's relevant. I guess it could be relevant, but I don't follow you as to how it would be relevant, other than she's sort of getting, she's getting, even though it's upside down, it's the business building that she's in, and all she has to do is pay the mortgage to keep it. So it's a good deal for her. The negative, a lot of us have buildings we're in with a negative value, but we got to be somewhere. Okay. So, it turned out good for her that the building itself was assigned to her in the equitable distribution.
Mr. Donald,
I guess I better stop.
Yeah, because you have 2 minutes left. I want to give you an opportunity at least for that rebuttal.
Okay, thank you, Your
Very
Honor.
good, sir. My pleasure. All right, Ms. Haverfield and Mr. Donald, I'm going to ask you now to mute your microphone. And Ms. Haverfield, I see you've unmuted. Excellent, ma'am. You may.
Did you say to mute my microphone?
Please,
Yes,
please.
please mute it. Okay.
Please. Thank you. So that way we could hear her clear. Very good, ma'am. You may proceed.
Thank you. Good morning. May it please the court, my name is Stacy Haverfield. And as Mr. Donald said, I represent the former wife who is the appellee in this challenge of a second amended final judgment. Boiled down, the judge got it right. When you get down to the bottom line of the distributions and the objectives that were contained in the second amended final judgment, the judge got it right, and we're asking that you affirm. This judgment does three major things. It distributes marital property and notes non-marital property, 1. 2, It affords a reimbursement for receivables and expenses paid by the former wife during the pendency of the litigation. And then 3, finds an entitlement to the former wife for attorney's fees. It's also important to note that the trial court was familiar with these parties. The trial court was assigned this case in 2011. The trial on the matter took place over 5 days at the end of March 2015. So by that time, the trial court was very familiar with the filings with the parties themselves. The trial court was in the best position to be able to assess credibility, assess the reliability of the information, weigh the evidence, and make the factual findings necessary to enter the order. He was left in a pretty tight position, I would say. The parties at the very beginning reached an agreement regarding certain what we refer to as good assets. This agreement was reached in 2009. The assets that were left over that weren't assigned or dealt with were those assets that were underwater, those assets that required constant and significant payments. Capital calls were being made, monthly ongoing expenses were happening. And the former husband opted out. And I mean opted out of paying, opted out of his obligation, not opted out of whether the property was marital or not marital. And, so to Mr. Donald's first point on the special equity, there was no special equity. If you review the attachment Exhibit 1, it does show the marital column and lists the husband and the wife, and it shows the non-marital column and it lists the husband and the wife. There is no $400,000 separate judgment against the former husband. It doesn't exist.
If I may, Ms. Haverfield, to follow up, I guess, with Judge Stargell and Judge Rothstein-Newcomb's question, in this case, as I review the facts, that the wife basically was almost like the sole party in many marital investments. And what the court was trying to do, as I see this, is trying to at least to try to do this unequal distribution, to try to level the playing field, for lack of a better word. Is that what the court was trying to do here, to make sure that at least the former husband to require to have him pay his share of the amounts that the wife at least did these things solely on her own? Am I reading it correctly?
Yes, Your Honor, you are. And basically it took 2 points. The first point was at the very beginning of the divorce proceeding, both parties were under this standing order, and both parties could have said, treat that as non-marital, I want no part of it. In fact, the record reflects that the former husband did that with one property, Tango 3. He relinquished any interest in that marital property, and the wife did not seek any reimbursement for it. So, that was an opportunity for him to, relieve himself of any ongoing obligation for payments of, like I said, capital calls, expenses, and these payments were significant. And also, just to, set the backdrop here, this was during the recession. So real property values were terrible. They were all, most of them were in the negative, and especially those heavily mortgaged. So you have that component. Plus, the former husband did not sign or obligate himself legally on any of the notes. He was not a guarantor. He was not an obligor. That was solely the former wife. She was the one, as you point out, Judge Kuzam, at the heart of this. She was the one with the decades-long experience. She was willing to teach him, but she was the one with the experience. She knew how to broker the deals. It was her name on the dotted line. So obviously, she had an interest in making sure that these properties were properly maintained. And knowing that, the former husband decided not to pay, and he had a choice. He could either weigh in and try to see how those properties were going to sort out at the end of the divorce proceedings, or he could opt out in the beginning and just relieve himself of any obligation. What he tried to do was play both sides. He wanted the former wife to maintain those properties all along, and then at the very end say, geez, I don't want them, just consider them non-marital. To circle back, that $400,000 is not an independent judgment. Again, Exhibit 1 shows that. So Exhibit 1, all the way over on the right-hand side, has the non-marital, and it has the husband and wife. And you can see at the very bottom on page 5, it lists the wife's $409,000 approximately, but it also lists the husband's $367,000. So the court in its final judgment recognized and noted that each party had non-marital property. But what the wife wanted the trial court to do was also to recognize, pursuant to the factors in A through J of 61075, wanted the trial court to note that she had contributed significantly to the enhancement of the marital pot by contributing non-marital funds. So when the trial court went through and conducted its evaluation of the factors A through J, it took note of that. It took note that the former wife entered the marriage at $3 million, where the former husband did not, and there was a significant difference. It noted that the former wife had sold her non-marital property and had used that non-marital property to buy marital property, and this is the office building that was being discussed, and also infused a partnership that was running a business. And she also was obligated to pay all these debts and obligations, and she was the one with the interest in doing so. The court noted that the communication between the two parties had broken down, and that the likelihood of them being able to get along in a partnership fashion post-divorce was very unlikely. And so because of this, to make sure that he considered all of the equities, the trial court then made this unequal distribution. Basically, the former wife got a bunch of debt and then the assets associated with the debt. That's what the former wife got the benefit of here. She didn't get a windfall. And even though the equalizer payment does assess a portion of the marital property debt, it assesses the reimbursed expenses and payables, and also takes into account the unequal distribution of the liability associated with Park Circle. It does not separately include the infusion of those two assets on which the former husband is focused. I mean, it deals with the property that was the result of the infusion, but does not count those items themselves in and of themselves. And so there's not an additional judgment of $400,000. Keep in mind that the former husband entered this marriage with, a house and a pressure cleaning business. The former wife took him under her wing, was willing to train him. They did work together in the business. But when things got tough, he did not want to participate any longer, which was fine. I mean, that was his prerogative. But in doing so, he should have then opted out of all the property, not waited around for the former wife to pay all the debts and obligations on his behalf, only at the end to see whether or not the property increased in value or not. Again, he rolled the dice, and unfortunately the properties were not the values that he wanted them to be. And so therefore, he participated in the marital classification, then he also participated in the debt that was associated with these properties. The court did not err in making an unequal distribution. The court really had no other choice in light of the assets the court had before it. It's also important to note, just to circle back to one of the points I made previously, the trial court had a lot of experience with these two parties. The two parties heavily litigated this matter. There were multiple hearings, there were multiple filings. In fact, at the pretrial conference just prior to the trial in March 2015, there were multiple memorandas of law filed, one of which was on unequal distribution. In the former husband's right, the former wife never claimed gift. That's inapplicable here. We're not interested in that. What we were interested in is just being credit given the factors that were listed in A through J. And that's what the trial court was trying to do. The fact that the trial court acknowledged that this was non-marital money put into the marital pot was the trial court just acknowledging all the different factors that are contained in 61075. At this point, the trial court did what it was supposed to do, and it got it right. I mean, there was really no other way to ensure that the former husband was not going to injure financially the former wife by failing to pay on the obligations, by shirking responsibility, by running up liability, like what happened in Park Circle. The former wife took great pains to try to, maintain her business, to try to keep things moving. She asked repeatedly for the former husband to disavow or relinquish his right, and she would take it over completely, no questions asked. But he didn't want to do that. But at the end of the day, he didn't want to pay either. So with that being said, if there are no other questions, we ask that you affirm the second amended final judgment.
Very good. Thank you, Ms. Haverfield. And I'm going to ask you now to mute your microphone. All right, Mr. Donald, you have your 2 minutes for rebuttal, and great, you unmuted. Very good. You may proceed, sir.
The chutzpah to say how the trial court was so on top of this case, I really asked the court to review the oral argument of this case before and the comments by Judge Morris. This trial judge said over and over again in this case that he didn't know what was going on. It was over his pay grade. He couldn't understand any of this. And he signed a 65-page judgment that literally said proposed at the top of it, okay? This trial judge, unfortunately, was not tuned into what was going on here. I think Ms. Haverfield has said this was an unequal distribution. Yes, there was an unequal distribution of anywhere between $600,000 and $800,000, not counting the $400,000, okay? There was an unequal distribution of that much. The $400,000 is on top of that. It's listed as non-marital property on pages 479 and 480 of the record. And even if it were somehow marital property, there was no proof that a gift to overcome the presumption of gift. So it's just improper no matter how you look at it.
You're getting close, Mr. Donald.
Okay,
I know. And I know we spend a lot of time, at the beginning, but if you just like to wrap it up really quick.
Okay, I will. The $3.2 million she brought into the marriage, the husband brought in $1.6 million. Her 3.2 was inflated for all the reasons stated in our initial brief. The briefs in this thing are very long and complicated, okay? Their original answer brief was 72 pages long. Our discussion today here has not even penetrated the upper level of this case. And I can only ask that the court actually go back and carefully review the points here, because there were numerous legal errors committed by the trial court here, who admittedly didn't know what he was doing and didn't allow any argument upon remand. So we ask that you look at it closely and reverse it, as we know you will. Thank you, Your Honors.
Thank you, Mr. Don. Thank you, Ms. Haverfield. Really very well argued, and thank you both. All right. So at this time, I'm going to ask you both to leave us, and we'll bring in the next group over at this time. And the next case